My father said he was just managing the family finances. I had no idea whose name he'd quietly removed from the will. The estate attorney slid a document across the conference table, and I looked at it the way you look at something that is clearly in your language and clearly addressed to you, and that nevertheless refuses to resolve into meaning for several full seconds. It was the most recent version of my mother's will, dated 11 months before her death, and my name appeared in it exactly once, in the clause that listed the individuals who had been explicitly and intentionally excluded from the estate. Not overlooked, not forgotten. Excluded. By name. With language that the attorney, a man named Reginald Akimpong, who had 23 years in estate law, and the particular careful stillness of someone who had delivered news like this before, described as unusually specific. The clause said that the exclusion was the deliberate and considered decision of the testator, and was not to be interpreted as an oversight. My mother had signed it. Her signature was at the bottom, recognizable, the same looping R she had used on birthday cards my entire life. The will had been prepared, notarized, and filed 11 months before her death. She had been diagnosed with early-stage dementia 14 months before her death. My father had been her sole caregiver and the only person with routine access to her affairs for the entirety of the period between the diagnosis and the signing. When I put my hand flat on the conference table and kept it there while Reginald continued speaking, and I could feel my own heartbeat in my palm, which is a thing that only happens to me when the body has received information the brain is not yet ready to process. I had been flying home for my mother's funeral for 11 hours when the call came that shifted everything from grief to something else. My name is Nana Asante Forjur. I am 38 years old, and I had been living in London for 6 years, working as a senior analyst for an infrastructure investment firm. I have one sibling, a brother named Kwabena, who is 4 years older than me, and who had lived within 30 minutes of our parents their entire adult lives, close enough to be present in the way I was not. My parents had been married for 41 years. My father, Miyakwasi Asante Forjur, was a retired civil engineer with the bearing of a man who had spent 40 years being correct in rooms full of people who deferred to him, and who had carried this posture into retirement without any apparent modification. My mother, Abina, had been a secondary school teacher for 30 years before she retired, and she was the center of the family's emotional gravity in the way that certain people are, not through dominance but through warmth, through the particular quality of being genuinely interested in every person she encountered, which made her easy to love and, I was about to discover, easy to exploit. She had been diagnosed with early-stage dementia 14 months before her death, which had come suddenly, a cardiac event in the night, and I had booked the first available flight and had arrived at the family home to find my father composed and my brother deferential, and everything arranged with the efficiency my father applied to systems he considered his responsibility to manage. I had thought his composure was grief-controlled. I had not yet understood that it was something else. The call that shifted things came from a woman named Dora Quainer, who had been my mother's closest friend for 35 years, and who I had known my entire childhood as Auntie Dora, which was how we addressed our parents' closest friends in the Ghanaian household I grew up in. Dora called me on the second evening, while I was sitting in my childhood bedroom trying to understand a particular kind of exhaustion that was partly travel and partly jet lag and partly the specific weight of being in a house that had belonged to someone who was no longer in it. She said she needed to tell me something that she had been sitting with for months and had not known how to say. She said my mother had called her approximately 11 months before her death on a day when my father was out. My mother had been confused about several things. This was the nature of the early-stage dementia. But she had been clear about one thing. She had signed papers she did not fully understand, presented to her by my father and a man she described as his lawyer, and she had felt while signing them that she should call someone but had not known who, and that she had called Dora because Dora was the person she called when she did not know what to do. Dora said my mother had been frightened. She said my mother had said the word frightened herself, which was not a word she used often. Dora had not known what to do with the call at the time, had believed my father when he explained it as estate planning, had pushed the call to the back of her mind where it had stayed until she heard about the will and understood what she had missed. I sat in my childhood bedroom with the phone against my ear and felt the grief I had been carrying begin to rearrange itself around something harder and colder and more specific. The funeral was on a Thursday. I attended it as a daughter who had lost her mother, which I had, and I behaved accordingly, or which required a sustained effort because I was also attending it as someone who had just received information that I was still in the process of organizing. My father stood at the front of the church with the dignified sorrow of a man presenting himself to a community that respected him, and I watched him from my seat in the family pew and thought about the word frightened in my mother's voice on a phone call to her closest friend 11 months ago. My brother Kwabena sat beside me, and I did not say anything to him yet, because I did not have enough to say, and because Kwabena had the quality of someone who had spent a lifetime calibrated to our father's frequencies, which meant the conversation required preparation. I had learned, over 6 years of living at a distance, I had to think carefully before I spoke to my father's proximity about things that concerned him, because proximity in this family operated as a form of agreement, and I was not in a position to offer agreement on anything until I understood what had actually happened. I met Reginald Achiampong the day after the funeral. He was not my father's attorney. He was the attorney my mother's oldest sister, Auntie Ifwa, had retained on my mother's behalf 2 years before the diagnosis, when my parents had done their estate planning together. He had the original will, prepared before the dementia diagnosis, in which the estate was divided equally between Kwabena and me. He had the amended will, dated 11 months before her death, prepared by a different attorney whose name I did not recognize, but in which I was explicitly excluded, and the entirety of the estate, the family home, valued at approximately £340,000 in the UK equivalent, plus savings and pension disbursements totaling approximately £180,000, went entirely to Kwabena. He showed me both documents across the conference table in his downtown office and explained, with the precise care of someone choosing every word, that the amendment had been prepared by a solicitor named Clement Aben, who had an office in a commercial district 15 miles from the family home, and who appeared to have had no prior relationship with my mother before the engagement. He said that the amendment had been prepared and signed within a 6-week window following my mother's diagnosis, which was the period in which the dementia was diagnosed but not yet documented to a degree that would typically raise guardianship questions. He said this timing was significant. He said it with the understatement of someone stating a fact whose full implication he expected me to draw myself. I drew it. Auntie Efwa was 71 years old and had the specific quality of women who have navigated complex family systems for decades and have developed, over that navigation, a clarity about human behavior that functions as its own form of intelligence. She had been suspicious from the moment of the funeral. She told me when I visited her 2 days after meeting Reginald. She said she had noticed, at the reading of the will, which my father had organized and which Reginald had attended as a representative of the original estate, that my father had not appeared surprised by the contents. She said a man who had not known what was in his late wife's will would have displayed some register of discovery. My father had displayed none. He had sat with his hands folded and his expression settled in a way that she described as already knowing. She had not been able to articulate this at the time, but the observation had stayed with her, specific and insistent, the way observations do when they are accurate and the observer is paying close enough attention. Auntie Efwa also told me something I had not known, that in the final months of my mother's life, she had attempted on 3 separate occasions to call me from her personal phone and found that the calls would not connect. My number, according to the phone's contact list, had been altered, a single digit changed, enough to route the calls to a disconnected number. Auntie Efua had discovered this when she borrowed my mother's phone to call me herself, found the wrong number, and corrected it. She had not thought it was deliberate at the time. She had thought it was an error made by someone with diminishing cognitive function. She said she now thought differently. So did I. I called a solicitor in London whose firm I had used for professional matters, a woman named Frederica Ansamensa, 12 years in civil and probate litigation, and described the situation in full. She listened the entire way through without interrupting, which was one of the first indications I had that she was good at her job. When I finished, she said, "I want you to understand that what you are describing, if it is what it appears to be, is undue influence over a testator with diminished capacity." She said this was a recognized and litigable basis for challenging a will. She said the elements required to demonstrate it were evidence of diminished capacity at the time of signing, evidence of opportunity for the influencing party to exercise control over the testator, evidence that the document did not reflect the testator's authentic wishes, and, if possible, direct evidence of inducement or coercion. She said we had strong indicators for the first 3 elements. She said the 4th was what we needed to find. She said, "Tell me more about this second attorney." I told her what I knew about Clement Aben. She said she would investigate his professional history. I said I had a name, my father's, and a clear motive. She said, "That's enough to start." I flew back to London 3 days after the funeral, not because the matter was resolved, but because I needed to work from a position of strategic distance rather than emotional proximity, which was something Frederica had said in almost exactly those words and which I recognized as accurate. The first piece of additional evidence arrived 14 days after I returned to London. Frederica had contacted the Law Society to request any disciplinary history connected to Clement Aben and had found something that she forwarded to me with a one-line note. This is significant. Clement Aben had 4 years prior to the will amendment been reprimanded by the regulatory body for a matter involving estate documents and a client with diminished capacity in an unrelated case. The reprimand had not resulted in license revocation, but had resulted in mandatory supervision for 2 years, which had expired 8 months before he prepared my mother's amended will. The nature of the prior reprimand was not publicly detailed, but its category, estates, diminished capacity, overlapped with our situation with a precision that was not reassuring and was potentially very useful. Frederica called it corroborating circumstantial evidence and said it established a pattern. I called Auntie Afua and told her. She was quiet for a moment and then said, "In Twy, your father knew exactly what he was doing." And she said it the way people say things they have known for a long time and have been waiting for permission to say. The crisis arrived on a Monday evening, 6 weeks after the funeral. I received a text from Kwabena that said simply, "Dad has listed the house." I called Kwabena immediately. He answered, and his voice had the quality of someone who has been uncomfortable with a situation for a while and has reached the point where the discomfort outweighs the loyalty that was producing the silence. He said our father had engaged a real estate agent that morning and intended to sell the family home within 60 days, which was the fastest timeline the agent said was realistic. He said the proceeds would go into our father's personal account, which was now the primary account given that the estate had been transferred. He said he had not been consulted. He said, "Nana, I don't think this is right." I said, "I know." I said, "How long have you known?" He was quiet. Then he said, "A few months." I don't know what I thought. I said, "I understand." I did understand. Kwabena had been in proximity for his entire adult life, and proximity had produced in him a particular kind of accommodation, the kind you develop when the alternative is a conflict you are not sure you can survive. I was not going to spend energy being angry at Kwabena when my father was about to liquidate the family home. I called Frederica at 8:30 p.m. London time, and she answered, which told me she had been expecting the call. Frederica said we needed to move immediately for a property preservation order to prevent the sale while the will challenge was in progress. She said we had a narrow window. If the sale completed before the order was in place, recovering the asset would require a separate and more complex process. She said she needed from me, that evening if possible, a written statement of everything I knew, supported by any documentation I had, and she would file the application the following morning. I sat at my kitchen table until 2:45 a.m. and wrote 14 pages. I included the phone call from Dora Quainer, with Dora's permission obtained by text at 11 p.m. I included the altered contact number documented by Auntie Afua's testimony. I included the timeline of the dementia diagnosis and the will amendment. I included the information about Clement Aben's prior reprimand. I included the valuation of the estate assets and the timeline of the proposed sale. Frederica filed at 9 a.m. Now, the following morning, and the application was heard at 2:15 p.m. the same day. The judge, a woman whose name was recorded in the documentation as the Honorable Justice Abina Darkwa, granted a temporary preservation order at 3:40 p.m. pending full hearing on the will challenge. The estate agent was notified. The sale was halted. My father received the order at 4:15 p.m. and called Kwabena, who called me, and I knew from Kwabena's tone when he called that our father's composure had finally cracked. My father called me at 6 p.m. that evening. I had been waiting for it and had made a decision about how to conduct the call that I'd rehearsed with Frederica, which was, do not argue, do not reveal the full extent of what I knew, do not give him information he could use to close avenues I had not yet pursued, let him talk. Albert, my father's voice was controlled and cold in the way it was always controlled and cold when he was addressing a situation he considered a challenge to his authority. He said I was being disrespectful of my mother's wishes. I said I was honoring my mother's wishes as she had expressed them before the amendment. He said the amendment was legal and properly executed. I said I was looking forward to examining that in court. He said I was causing family damage that could not be repaired. I said I was preventing asset damage that could not be repaired. He was quiet for approximately 5 seconds, which was the longest pause I had ever heard from him in a conversation, and in that pause I heard, for the first time, something that was not composure, something more like recalculation. He said, "We can discuss this as a family." Mo, I said, "My attorney will be in contact." I ended the call and sat with my phone in my hand for a long time and thought about my mother calling Dora from a quiet house because she did not know who else to call. The formal will challenge hearing was scheduled for 12 weeks out. In those 12 weeks, several things happened that I want to account for with the precision they deserve. The first was the deposition of claimant Aben, which Frederica conducted with the methodical patience of someone unwrapping a process she had done many times. Aben was 54 years old, compact and carefully dressed, with the specific quality of a professional who had made certain accommodations over his career and had developed a way of discussing those accommodations that was technically accurate and substantively evasive. Under Frederica's questioning, he confirmed that my father had been the party who initially engaged him. He confirmed that my mother had been present at the signing, but that the meeting had been brief. He confirmed that a formal capacity assessment had not been conducted. He said this was standard practice for estate amendments of the type requested. Frederica asked him whether he was aware at the time of engagement that my mother had received a dementia diagnosis 2 months prior. He said he had not been informed of a diagnosis. Frederica asked him what steps he had taken to assess the testator's understanding of the document she was signing. He described a verbal confirmation process that lasted, by his own account, approximately 3 minutes. Frederica's expression during this answer did not change. She thanked him and moved on. And in her summary notes to me afterward, she described the deposition as providing everything required to support the capacity argument and added, "He knows what he did, and he did it anyway," which is a different kind of problem and a more useful one for our purposes. The second development was a conversation with Dr. Ya Opong, a geriatric specialist who had been my mother's treating physician from the point of diagnosis, and who had agreed, following a formal request through Frederica's office, to provide a retrospective capacity assessment based on her clinical notes from the relevant period. Dr. Opong had 19 years in geriatric medicine and the specific directness of a clinician who understood that her testimony had consequences and took the responsibility seriously. She reviewed her notes from the 14 months between diagnosis and death and provided a written assessment that stated the following. At the time the amended will was signed, my mother's documented cognitive status was consistent with early to moderate progression, characterized by significant short-term memory impairment, vulnerability to suggestion, difficulty evaluating complex information, and a documented tendency to defer to trusted figures in her immediate environment when presented with decisions she found confusing. She said that in her clinical judgment, a document of the type described, a will amendment specifically excluding a named beneficiary, exceeded the level of complexity my mother could have independently evaluated at that stage of her condition, and that any such document should have been accompanied by a formal capacity assessment conducted by an independent evaluator. It had not been. Dr. Opong's written assessment was filed as Exhibit C in the court proceedings. I read it 3 times when Frederica sent it over. The 3rd time I read it, I had to put my phone down because my hands were unsteady, and there was a specific image in my mind that I could not dislodge. My mother in that lawyer's office, with my father beside her and a document in front of her, trying to understand something that had been deliberately constructed to exceed her understanding. The hearing itself lasted 2 days. My father appeared with an attorney named Kweku Sarfo, who had a reputation in local probate circles as someone who argued technical compliance vigorously, which was accurate. Sarfo spent the first half of the first day establishing that the document had been properly executed, witnessed, and filed according to all applicable procedural requirements. He was not wrong about any of this. The document was technically compliant. Frederica's position had never been that the document was procedurally defective. Her position was that the document was the product of undue influence exercised over a person who lacked the capacity to independently evaluate it. She presented Dr. Opong's assessment. She presented the deposition transcript from Clement Aben, specifically the section confirming that no independent capacity assessment had been conducted and that the meeting lasted 3 minutes. She presented Dora Quainer's written testimony about the phone call, that which Dora had agreed to provide and which had been formally notarized. She presented Auntie Efua's testimony about the altered phone number, supported by a phone technician's written confirmation that the contact entry had been manually edited within the period in question. Kweku Sarfo objected to the phone evidence as circumstantial. Justice Darkwa noted the objection and admitted the evidence. My father sat at the opposing table through both days with his hands folded, and I watched him the way I had watched him at the funeral, looking for what the composure was covering. On the second afternoon, during Dr. Opong's testimony, his hands unfolded. He placed them flat on the table. I noted this. It was the same gesture I had made in Reginald's office when the document was first placed in front of me. Yeah, I recognized the sensation it indicated. Justice Darkwa delivered her ruling 16 days after the hearing concluded. I was in London. Frederica called me at 10:22 a.m. and said, "We won." The ruling found that the amended will had been executed during a period in which the testator lacked sufficient capacity to independently evaluate its contents, that the absence of independent capacity assessment constituted a material failure, and that the circumstances surrounding the amendment, including the identity of the instructing party, the brief execution meeting, and the explicit exclusion of a named beneficiary, were consistent with undue influence as defined in the applicable case law. The amended will was set aside. The original will, prepared before the diagnosis and dividing the estate equally between Kwabena and me, was reinstated. Like the estate assets, including the family home, were to be administered according to the original document. My father was ordered to pay legal costs. I sat with this information for approximately 10 minutes in my kitchen before I called Auntie Efwa. She answered on the second ring and I said, "We won." She was quiet for a moment. Then she said, "Your mother knew." She said it with the certainty of a woman who had known her friend for 35 years and understood what that phone call had meant. I said, "I know." She said, "She called Dora because she needed someone to know. She could not stop what was happening, but she needed a witness." I said, "She got more than a witness." Auntie Efwa made a sound that contained several things at once, and I did not try to identify all of them. My father did not contact me after the ruling. Kwabena called and we talked for 2 hours, the longest and most honest conversation we had had in years, possibly in our adult lives, which is one of the things that happened as a consequence of what our father did that I had not anticipated and that I do not know how to characterize simply. Kwabena said, "I should have said something sooner." I said, "I know." He said, "I didn't know how." I said, "I know that too." We talked about our mother in the way that people who have shared something difficult with someone, they have lost talk about them, with the specific texture of grief that has been rearranged by what came after it, neither simpler nor more complicated, just differently shaped. Kwabena said he was going to recommend to Frederica that the estate administration proceed jointly, with both of us signing off on every significant decision. I said that was the right approach and I appreciated it. He said, "She would have wanted that." I said, "Yes, she would have." The family home was not sold. It was rented, generating income that was divided as the original will specified. I visited it 8 months after the ruling, the first time I'd been back since the funeral, and I stood in the kitchen where my mother had cooked every Sunday morning of my childhood, and I looked at the room and tried to find the feeling I had come looking for. It was not clean resolution. Nothing about any of it was clean. What I found instead was something quieter. The specific recognition that she had tried to reach me in the last months of her life by whatever means were available to her, and that even when those means were narrowed and altered, she had found a way to leave a mark. The call to Dora. The way Auntie Efwa had watched our father's face at the reading and had remembered what she saw. Small things carefully made by someone whose tools were being taken away one by one. She was a teacher for 30 years. She knew how to leave material that the student would find later when they were ready for it. Frederica referred the case to the relevant professional body regarding Clement Aben, citing the evidence of his prior reprimand and the similarities between the two cases. His license is under review. The matter is ongoing. Kweku Sarfo, my father's attorney, is not subject to any professional consequences. He argued a position, which is his job, and he argued it in good faith as far as the record shows. My father has not been charged with anything. What he did exists in the space between what the law reaches and what it doesn't, which is a space that careful and patient people have always known how to use. He is 71 years old and lives in a house 15 minutes from Kwabena and receives the civil minimum of contact that a family with unresolved damage manages to sustain. I do not call him. I do not pretend that the calls I would make would be productive. What I do is send a card to the family home every year on the anniversary of my mother's death. addressed to no one in particular, with a photograph of her that I took at a beach vacation in 2016 when she was laughing at something my brother had said, and the light was the specific amber that exists in that window just before sunset. I do it because she would have wanted the house to hold something of her, and because leaving a mark, however small, on something that tried to erase you is the oldest form of presence there is. She knew that. She taught me.